Let's start off with the verbal formal report. This is the one where you had to do lots of practice and get ready to talk, because this is going to be in front of the people who are going to make the decision. This could be the jury. You've practiced this prior to getting to that point, and you're working with an attorney to say, this is the documentation that I want to cover. You may have this, maybe you have 10 points that you think should be covered, and that's all of the evidence. The attorney only wants to cover 4 of those points. The attorney's driving the bus, you're just a passenger on it, so make sure you know where you're going. You should set things up to say, okay, what are the expected questions and the relevant answers to that that'll guide the investigation to where you're going. The investigator can propose clarification and definition, and that usually happens in the testimony part of that. We'll get to the expert witness testimony and how that works in the next module. So as the investigator, you should include the things that are relevant, and make sure that you don't harp on the things that the counsel has said, let's stay away from those elements in the set, because they know the legal proceedings of it and the introduction of evidence. If you are on the if you are in defense at that moment in time, what happens is anything that you bring up can then be later questioned, and now it's in evidence. It can now be questioned by the opposing counsel. So if you don't bring it up and you only have those 4 things, and those are 4 rock solid things, and the other 6 are kind of weak and could weaken your case, since you haven't introduced them in this verbal formal report, then the opposing counsel can't go after those things because they haven't been introduced into evidence. Now there is the informal report. This is beforehand. This is kind of at that prep stage where you're talking to the counsel, and this is when you say, here's the 10 things that I've found. What is your focus and the importance here? It's submitted, really, you could say it's submitted to the attorney's office, but it's usually submitted to the attorney, and you have a discussion about it. So you're going to do an informal report, they're going to review it, and then you're going to have and that's going to be written, and then you're going to have a verbal informal report about that informal information, so they can say, here's the highlighting. So this is areas to investigate in the report. So you might just say, I think on this phone that we can get these items right here, and they're going to lead to this. And he says, okay, dig deep in that area. That's kind of what happens in the verbal informal. Okay, written formal report. This represents you. You may never, ever show up. It may never go to court. So this has to be as good as it gets. Remember, this is an affidavit that in most cases you're going to have to swear to under oath. So make sure it is very scientific. Make sure that it is void of all opinion, and let opinion be given after the fact. When you're dealing with this, make sure that you're writing in first person, and learn what first person is. And for that formal report writing, an investigator should use natural language. Try not to be so wooden about it, is the best way that I can describe it in the written formal report. You want to use the concept of analogy in a lot of cases, because the people who are reading this are jury members, and they might have not have any information as it pertains to forensics. They may not know anything that you're doing. So you have to make it easy for them to read. I always tell my students that if you're going to write a report, write it so that your mom can read it and understand it and be proud of her son or daughter. Informal report. Okay, this precedes the main event of the particular case. These reports are high-risk documents because they reveal a lot of information that you may not want to come to light at trial, or doesn't help the attorney in their case, so they don't want to highlight them. It's not that they're hiding evidence, it's just that there's a lot of evidence in there that they want to focus on the things to get this quick, efficiently over with and make sure that it works. Your job is to collect it all and then let them go ahead and say, no, we want to focus on this. We want to do this plan. But they need that informal report so that they can make their decisions. Now, here's the thing, and look at this third bullet point here. The opposing counsel will receive the document in discovery. Now, I changed the word to will. Here's the thing. There is a possibility that they'll receive this document in discovery. And if there's the slightest chance or the slightest possibility of this, you need to act as if they're going to get it. We'll talk about expert witnesses and what can happen with this written informal report in that next section. So you want to include the contents of a written informal report. You want to make sure that you've got everything there, a good table of contents. And remember, the investigator shouldn't destroy the written informal report. They should keep it protected, treat it as if it was the evidence. Now, a little sidebar here is signature analysis. This is signature of the file. This is hash values of the files to maintain the integrity of that evidence. So you need to know that the files haven't been renamed, and there aren't a bunch of different files with the same identity. Because remember, we're hashing the contents of the file, not the actual name of the file, unless that's embedded inside of it. So those signature types can tell you, in signature analysis, they can tell the people that are reading your report that you actually understand at a core level what the value of this report is and how sensitive this information is, and that you can prove that you've maintained that chain of custody. So you need to communicate that to them. In the layout of your investigative report, you really want to make sure that things are consistent. There's a predictability of the way the report is written, so you can lead those people through the evidence, but they know that at the top of the page, let's say, for instance, you're going to have a summary sentence, and you're going to have 5 bullet points, and then you're going to have a diagram down below it. Do that exact same thing for all of the different pages of the report, for all of the different pieces of evidence, so that they can look at that. And even if there's a whole page of explanation behind that, that's fine, but they can look at it and say, okay, this is the start of a new piece of evidence. And then this is the start of a new piece of evidence. That consistency, that getting the writer used to the way you've laid things out, will make them consume that report a little bit easier. Remember to tune your language correctly and try to have the technical information behind or in the appendices, and make it natural language, make it easy to read. You should avoid any kind of inflammatory statements, anything that looks like opinion. Focus on the facts and the science of the case. One of the other things that we do in presenting these cases to make it easier on the reader is we set up a sequencing number that is accepted by the audience. So let's talk about your first audience. The first one is the attorney, and they're used to the legal sequencing number. And here's an example of that legal sequencing number. They're used to that, so give them what they're used to. The second person that's going to read this, if it makes it that far, is the opposing counsel. They're used to it, so give it to them. And then it reaches the judge. The judge has seen this a lot. The only people that aren't used to this are the jury in most cases. So the first 3 people, you got to get past them. You got to jump over that bar before you can get to the jury. So use the sequencing number that is appropriate for them.